Assalamu alaikum wa rahmatullahi wa barakatuh. Alhamdulillahi rabbil alameen wa sallallahu wa sallam wa baraka ala abdihi wa rasulihi nabina Muhammad wa ala alihi wa sahbihi ajma'een. Amma ba'd, ahlan wa sahlan wa marhaban bikum. I welcome you all to our third installment bi'idhnillahi ta'ala of the weekly dosage, which we've started a few weeks ago. Alhamdulillah, our first gathering we went through worst of the worst, biographies of the criminals in the seerah of the Prophet sallallahu alaihi wasallam. And those of you who missed that, it's already been uploaded to YouTube. You can just find it on YouTube, or if you go to Deen Class on Facebook, you'll find it bi'idhnillahi ta'ala. Then last week we had Sheikh Musa'id with us, and he went through the various names, the beautiful names of Allah subhanahu wa ta'ala, and he picked out wisdoms from various names. And that also bi'idhnillahi ta'ala either today or tomorrow would be uploaded insha'Allah. Alhamdulillah, this week we have with us our brother and lawyer MS Omar. Bi'idhnillahi ta'ala, he will be going through matters pertaining to family law, Islamic family law, and Muslim women living here in South Africa. And those of you who have questions, etc., please write them down and you can send them forward at the end of the discussion. Also, we know that MS Omar has been closely involved with the MPL. You hear every now and then issues and problems. If you subscribe to certain newsletters, etc., you are updated with information. Those of you who have questions, etc., you're free to ask them, insha'Allah. Hayyakumullah, jazakumullahu khairan. Falyatafaddal.
Jazakumullah. Bismillahir Rahmanir Rahim. Nahmadu wa nusalli ala Rasulil Kareem. Amma ba'd. Muslim family law can be best Muslim family law can be best illustrated by examples. When we speak about Muslim family law, we are speaking about the law of Allah subhanahu wa ta'ala, which is contained in the Holy Quran, and of course the prophetic model. And in that regard, Muslim family law is in a sense very integral. It goes to the heart of the Muslim personality, because the preservation of Muslim family law, its enhancement, is directly connected with the preservation of the Muslim personality itself. It is connected with the distinct Muslim ethos. It is connected with the distinct Muslim character. Now, though that being said, we can perhaps I can go directly into the topic by referring to some practical examples, because I think the examples will then illustrate the point. There's a danger that if I go too much into theory and detail, the subject may become academic. But if we look at some of the examples, practical, live, real-world examples, then in that context we can discuss some of the issues that arise in relation to both the recognition of Muslim family law in South Africa, its application and its enforcement. Now, let me give you some examples, because this, as I indicated to you, this subject may be best illustrated by examples. Firstly, you have two prospective two prospective persons who want to get married. So you take an example of Zaid and Amina. They are proposed to get married. Now they want to conclude an Islamic marriage, a nikah. So the first question that arises is, what do they do? Do they enter into a marriage contract in terms of the Sharia? What should be the terms and conditions of this marriage contract? What are the permissible terms and conditions that can be incorporated into such a marriage contract? What is the position of all the mazahib Hanafi, Shafi, Maliki and Hanbali schools in relation to the category of conditions that can be incorporated into a marriage contract. Is such a marriage contract desirable, particularly within the South African context? What kind of, well, as I indicated to you, the conditions that should be incorporated in a marriage contract, should we include, for example, a condition like a tafwidut talaq, which I will discuss or perhaps mention. So that's one example, and that deals with marriage contracts. Then is that marriage contract that they conclude in terms of the Sharia valid in terms of South African law? Right. And the next question obviously arises in their mind, should they then look at the civil law and convert the Islamic marriage into a valid marriage in terms of the civil law? So that's the one important issue from the standpoint of Muslim family law, and that is the marriage contract, the aqdul ziwaj, the one that before parties conclude a nikah, should they enter into a marriage contract, and what should be the nature of that marriage contract and the terms and conditions from a Sharia standpoint, and is that enforceable in terms of South African law? So that's the one issue I will discuss shortly relating to marriage contracts, because I believe that marriage contracts are very critical, and if we have a well-organized, properly regulated marriage contract in terms of Sharia, that contract will be binding in terms of South African law, it will be valid in terms of Sharia, and it will assist, that contract will assist in the resolution of any disputes or differences as these disputes or differences may arise in the future. Right. Obviously, the whole question of marriage contract is a subject on its own, and really should be illustrated by one contract, and should be debated really at a workshop level with a draft contract and what conditions should be included, and there's a whole host of jurisprudence in the classical fiqh relating to marriage contracts. Or perhaps while I'm on this topic, and before I go to a next example, let me just, since we are talking about marriage contracts, just give you the position of Islamic law on marriage contracts, the classical fiqh position. You find that amongst the mazahibs, there is a difference of opinion as to what condition can be included in the marriage contract. All the mazahibs are agreed that you cannot include a condition in an Islamic marriage contract which is contrary to the very essence of the contract. So in other words, when we say contrary to the essence of the contract, it means this. As soon as when a valid nikah is concluded, certain rights and responsibilities arise from that contract. Important rights and responsibilities. Right? Obligations and rights. Just as the Holy Quran says, وَلَهُنَّ مِثْلُ الَّذِي عَلَيْهِنَّ بِالْمَعْرُوفِ. Women have certain rights and obligations, men have certain rights and obligations. So, in this context, if you put in a condition, for example, one of the key obligations that arise from an Islamic nikah is that the obligation to maintain the wife and any children born of the marriage is vested in the husband. Right. Now, based obviously on his financial means and the needs of his spouse and any children born of the marriage. So that obligation is an invariable obligation from Sharia perspective. If you change that in a marriage contract and say, for example, that obligation will now pass on to the wife, then that's invalid. That's contrary to what we call the muqtada al-aqd, the essence of the contract of marriage. But outside that small circle, there's a wider circle, right? Outside the small circle of invariable consequences which are contrary. For example, you want to put in a condition that the husband and the wife will not cohabit together. That's contrary to the essence of the conjugal relationship. But outside the small circle, there's a wide circle. The mazhab that is most broad in this context and permits the maximum latitude to incorporate conditions is the Hanbali fiqh. In terms of the Hanbali fiqh, and also as explained and elaborated by Ibn Taymiyyah rahmatullah alayh and Ibn Qayyim in his Ilam al-Muwaqqi'in, the Hanbali fiqh says that the original position that is that any condition that is inserted in a marriage contract, right, which is not contrary to the essence, the muqtada al-aqd, is a valid condition. So that gives you a whole host of opportunities. Of course, the classical fiqh gives you many examples, but to take one example, for example, the husband undertakes in the marriage contract that during the course of his marriage he will not enter into another nikah with another woman. That condition is a valid condition. Of course, if the husband breaches that condition, then the wife has a right of fasq. She can approach a qadi and have that marriage dissolved based on a breach of that condition. Then there are lots of other conditions you can put. For example, you can put a condition that the parties will reside in a particular area, and so forth. For example, amongst the fiqh academies today, you've got the Islamic Fiqh Academy in India had a special seminar, or at least seminar, where they invited jurists, Islamic scholars and ulama to discuss this issue as to what conditions should be incorporated and should not be incorporated in a marriage contract. They essentially moved away from the Hanafi, the Jumhur position, and they adopted the Hanbali fiqh. And they have in their published volume, they have a standard contract that they have recommended, but of course it's just a specimen, and you can incorporate. So within the South African context, it is important, I think, that when prospective parties want to get married, they should look at a marriage contract. In that contract, you can incorporate a mediation clause, right? Like for example, the Holy Quran says that فَإِنْ خِفْتُمْ شِقَاقَ بَيْنِهِمَا فَبَعْثُوا حَكَمًا مِنْ أَهْلِهِ وَحَكَمًا مِنْ أَهْلِهَا. If there's a dispute, a shikak, a serious matrimonial dispute between husband and wife, then appoint one arbitrator or one mediator, depending on which interpretation you take, from his family and one from her family. And so mediation can be incorporated, or arbitration can be incorporated as a clause in the marriage contract, right? Some advices can be incorporated in the marriage contract. Provisions relating to, compassionate and sort of kind sort of relationship between spouses can be incorporated in the marriage contract. Then, of course, you got the Hanafi paradigm of tafwid al-talaq. That could also be incorporated in a marriage contract. That's not limited. The tafwid al-talaq in the Hanafi fiqh is not limited only to the time of marriage, but it can be effected even after marriage at any time. For example, in Pakistan, in the nikah certificate, they have a tafwid al-talaq provision. You could tick it off or not. Essentially, in the Hanafi fiqh, the tafwid al-talaq is a situation where we all know by consensus, in terms of the Holy Quran, the right of talaq is only vested in the husband, right? But in the Hanafi fiqh, the right of talaq can be transferred. The husband can assign, if I want to use the word tafweed, assign, the closest English translation. He can assign the right of talaq to the wife or to a third party or to an arbitral tribunal or to a specific number of persons. It could be unconditional or conditional. What that means, if he transfers it to the wife, unconditionally or conditionally meaning you can only exercise the talaq in certain circumstances, whenever she wishes. Of course, there are rules regulating this. If it's carefully worded, what it means is the husband doesn't lose his right of talaq. But simultaneously, if he assigns the right of talaq by way of tafweed, the wife also has a right of talaq. It may be conditional or unconditional, right? So, in the future, in the course of the marriage, if there is a dispute, for example, it's a very serious dispute, Then the matter goes, in terms of the contract, goes for mediation. The mediators try their best, and ultimately both mediators come to the conclusion that this marriage has irretrievably broken down. We call that a shikak, right? In modern law, irretrievable breakdown. So in that situation, then depending on the terms of the tafweed, if it's given to the wife, she can pronounce the talaq. One talaq-e-bain, and the marriage is dissolved. Or the tribunal can pronounce it, or it could be given to the executive committee of a particular organization, president of Al-Kawthar or some Jamiat or some Muslim judicial body can say, right, if he is satisfied that the marriage has irretrievably broken down, every attempt at reconciliation has proved abortive, right? There is no reasonable option other than to terminate the marriage, then the president can also pronounce the talaq, right? That is valid. So the Hanafi fiqh here has, it's quite broad in this context. Obviously in the other schools, you can have what we call a tafweed talaq, but that has the effect of what we call tawkeel. It's an agency to the wife, right? The moment we speak about a principal and agent relationship, then it means that the husband can revoke that agency. So it's not so strong. But in the Hanafi fiqh, so we've got the provision of what we call tafweed talaq. So marriage contracts are really very effective instruments, I believe. The problem in South Africa is we have not educated the Muslim community about marriage contracts. So immediately when a proposal comes to the lady, and then the parties want to marry, now the father of the wife it's such a sensitive issue, too scared to even raise it with the boy's parents, because you know what, people are not aware of these things here. These are sensitive issues, but through education, proper education, we can bring this subject, if people get educated about that, this is nothing extraordinary. It's recognized by the fiqh. It's a matter to be negotiated between the parties, bona fide, in good faith. Then you can have a marriage contract, right? And in the Muslim marriage bill, which I will mention a little later on, maybe towards the end, which is currently being considered by the Ministry of Justice, we have provision for marriage contracts. And if that bill does if it does become law, inshallah, eventually, on a Sharia compliant basis, then we're going to prepare marriage contracts, specific form of marriage contracts, which will be available to prospective spouses. They will have different options. Of course, you can even have partnership arrangements in terms of Sharia, which is another subject now. It falls more on estate planning. But partnership arrangements, like an Inan partnership, maybe not in the marriage contract, but later on, where husband and wife enter into a partnership, in terms of a Sharia compliant partnership, which is enforceable in terms of South African law. And in terms of this Sharia compliant partnership, the wife may own 50% of the assets, the husband may own 50%, or any other proportion that they may agree upon, right? So, but that's another subject that will require, in the limited time available, I won't be able to speak on because each subject is. But what I would suggest is marriage contracts. Maybe Al-Kawthar can look at this subject on its own and have a proper seminar in due course, where this matter is properly debated, a draft contract is presented, and some of the clauses are debated, and the participants can give on an interactive basis some inputs, so that we can try and work and get a Sharia compliant contract which the community could use, right? But this kind of contract can save a lot of problems also. I mean, we had the Jamaluddin case I mentioned, in which I was involved, where the parties were married only in terms of Islamic law, right? And the husband talaqed the wife, for whatever reason, right? That's not relevant to this. But then the wife claimed half of his estate, and he claimed half of on the basis that a community of property is recognized in terms of Sharia. Now, as we know, the original position is in terms of a nikah. The party, there is no community of property. Each spouse owns their separate estate, because Islam recognizes ahliya, independent, each spouse has full contractual capacity, they own their own assets. So there is no merging, there is no automatic merging of any assets. Assets can only be merged through a recognized Sharia contract, through a recognized Sharia instrument, a recognized Sharia partner, Shirkatul Milk or Shirkatul Inan or Shirkatul Mufawada, that kind of thing. Now, so that comes to, that was the case. Fortunately, it got resolved at some stage, and so it didn't go. But now we are getting, but if you have an Islamic contract where you say in the contract up front that what belongs to the husband is the husband's, what belongs to the wife is the wife, then you won't have that kind of problem, because it's in writing, it's enforceable under our constitution, because the constitution now recognizes all marriages on a par, would recognize a contract. A contract like this would have been against public policy in the old days, pre-apartheid. Now it's a valid contract, right, in terms of our constitution. So so that kind of contract, I mean, recently I've seen a case where it was brought to me where the wife, the husband talaqed the wife, and the wife issued summons from Johannesburg, and she sued her husband, and she alleged that they entered into a universal partnership under the common law, you know. So now universal partnership under the common law has different connotations, but whatever it is, you see, because they didn't have an Islamic contract, it caused a problem. Now he's in trouble because he's got to fight this case. It's going to be expensive. He's got the husband has got a good position. He's working for an established financial institution. Therefore, I mean, he's got a pension fund, big amount to be paid out. So it becomes a money issue. So they look for a loophole within the law, and that will bring me back to the question of Muslim personal law when I give you more examples which will illustrate why we need a viable statutory framework to enforce Muslim rights and obligations within the framework of Muslim family law, ahwalu shakhsiyya. Right. Now that was marriage contracts in brief. You must stop me with time. Because I can carry on talking. I've got a bad habit. I haven't prepared, so I can just carry on. Right. The second thing is what now? Briefly, I touched on marriage contracts, which I believe are very important and crucial. Then the second issue, of course, is the issue. Let me give you some examples again. Husband and wife. Let me take the example of, but these are real examples. I'm giving you from experience what happens on the ground but I'm taking these examples so that it becomes more meaningful, when we speak about these things. Zayd and Amin are married for 7 or 8 years. 2 children are born of the marriage. Marriage irretrievably breaks down, right? For whatever reason. We're not here to apportion fault. I mean, the reality is, one party wants to reconcile, the other doesn't want to. But it's a shikak finish. You can't, one party is an out, or sometimes both parties may want an out. But in this case, one, right. So here you have a situation, they're only in an Islamic marriage. So when you're in an Islamic marriage, then obviously you want to enforce the rights and obligations flowing from the marriage. So now, once the talaq is issued, then there are issues that follow the dissolution of a Muslim marriage, right? Maintenance. The husband is obliged to pay maintenance to the wife for the period of iddah, according to some schools. And obviously, he's got to maintain the children based on his means until they become self-supporting or, are free of need, right? Now, so that's the first issue. There's a dispute relating to the quantum of maintenance. In one case, you may say, you know what, I want to pay 1,000 rands. The wife says, no, you must pay 5,000 rands per child. There are 2 children born of the marriage. So there's an issue. Now, who's going to decide the quantum of maintenance, the amount? that requires a process, a judicial process to decide that, right? Somebody has to decide that issue. And how do you enforce that? Remember what Hazrat Omar radiallahu anhu said when he issued the first constitutional charter, when he appointed Qazi Shurey to be a Qadi, and he sent him a well-known revolutionary, it's a revolutionary statement in the context of Islamic judiciary, but I think in the context of all judiciaries and laws, where he gave him some advices. And the key advice was right in the beginning of that directive. He said that, what is the point of speaking about rights la nafaza laha, that have no enforceability? You can't speak about rights that have no enforceability. Quwwatut tanfiz, nothing. You know, you go to Sheikh Bilal here, and he says, he hears the parties, he says, fine, I've got all the information, I've considered the matter. He gives a ruling, and he says the husband must pay the wife, he's seen the pay slips and he's done the groundwork, you must pay, for each child you must pay 3,000 rands a month, 6,000, right? Husband says, no problem. He walks out and he doesn't fulfill that obligation. How do you enforce it? So you need a viable statutory framework to enforce these obligations. Now, under the civil law, we've got a statutory framework. We've got the Maintenance Act, we've got the Divorce Act, we've got the Marriage Act, if you marry under the Marriage Act, we've got certain associated legislation, right? Now, similarly, in Sharia compliant to enter into Sharia compliant relationships, valid to enter into a proper nikah and have Sharia compliant obligations flowing from that nikah, we need a statutory framework, because how you start, you need rules of court, you need a legal framework. So you can say, if there's a matrimonial breakdown, you have mediation, then you have potentially arbitration, then you have a court determined resolution of the dispute in terms of the Sharia. You have husband or wife issuing a summons confirming the talaq, dealing with all the consequences of the marriage. And talaq, maintenance is just one consequence. The next consequence is what we call hadana, custody, right? Who's going to look after the children? What are the Sharia rules relating to that, right? And then other property issues arising out of the marriage, right? Husband and wife maybe work together in the family business, or, today in South African society, we have to bear in mind that things have changed now in a secular society, right? In many cases, both husband and wife are compelled to work to support the joint household. The earnings of the one party is not sufficient to support the joint household. So what they do, they work together, the income comes into a common pool, right? They use the money to buy furniture, they pay the household utilities. If they have entered into a Sharia compliant arrangement to fund their apartment or their home, or maybe they went to a conventional institution, they contribute jointly to the monthly installments, they bought a car. Now, they don't keep separate records. It all gets mixed into one pool, makhlut, So at the end of the marriage, there has to be a takharuj. There has to be some arbitrator. We're not talking about intangible contributions under the Western law. That's where the confusion comes. Under the Western law, you have what you call intangible contributions. The wife assisted in cooking and looking after the children. We're not talking about that. We're talking about tangible contributions in monetary terms. But because they're mixed and we don't have a separate record for it, so it's all mixed. Therefore, by reason of that, you need some process to resolve that problem. Right, the Muslim Marriage Bill, that was the product of initially the South African Law Reform Commission, right? Then it went through a collective, extensive process of consultation. Firstly, there was an issue paper, discussion paper, a number of workshops. The United Ulama Council was involved. on an ongoing basis. So this bill then creates a statutory framework. It makes provision for mediation, voluntary arbitration. If we get that, that will be a great asset, because in terms of South African law at the moment, matrimonial matters cannot be enforced through an arbitral process. We have an arbitration act, but that only applies to commercial arbitration, corporate disputes, commercial disputes, but the jurisdiction of that act doesn't apply to matrimonial matters. So you've got to go to court for matrimonial matters. If the community supports this process of voluntary arbitration, we can get it embedded in the bill. It's there in the bill. Well, it was not in the last version that the Ministry of Justice issued, but recently we made some further submissions to the Ministry's task team, and they wanted some inputs on 4 key issues. And I made these submissions on behalf of the United Ulama Council, and one of the things I emphasized was to make sure that arbitration is reincorporated into the bill. There were other issues relating to getting a Muslim judge to sit as a jurisdictional requirement, supported by 2 competent Sharia scholars who can assist the judge in arriving at a conclusion. But if you get arbitration accepted, then we will get community organizations accredited under the bill. Right? You'll have Jamiats, you'll have Kausar, you'll have different bodies who will be accredited. They'll apply, they'll get accreditation, they'll have their own arbitration council, and these councils can then arbitrate disputes. So if we can get this through, if we stop fighting and arguing and eventually try and achieve some positive consensus, then it will be a very great plus. In fact, the other communities will see us on the same basis and say, well, you've got voluntary arbitration, it's workable. Of course, arbitration is always a double-edged sword, because you need competent arbitrators, but that's not a problem. That's a matter of training and a matter of development. Rome was not built in a day. Everything develops over a period, right? Those things can be, we can work around that, and we can give the requisite training. The expertise is available. That's not a problem. But that arbitration award that will be given by the arbitrator will have to be rubber stamped by the High Court. That you cannot avoid, because that's in terms of the law. When there are minor children born of the marriage, the court is the upper guardian of minor children. That principle is inflexible in terms of South African law and many other jurisdictions. They always monitor the interests of minor children, the courts as the upper guardian. So if we get arbitration and the arbitrator makes an award and a ruling, then all that will happen is that award will be rubber stamped by the court. You make an application, see a judge in chambers, and have it endorsed, and then it becomes legally enforceable. Right? So that was at the level I mentioned about the statutory framework. Right? We're not living in an ideal society, so there'll always be problems. But if we have a proper statutory framework, you'll find that the bulk of your disputes, 95% of them, will be resolved moment that framework is triggered, legally triggered. Moment a person gives a talaq in Cape Town, he's got 2 children, he runs away to Durban, he can't evade his obligations, because immediately that talaq has to be registered. It takes immediate effect. It's got to be registered. That wife will issue a summons for confirmation of the talaq, for matters and for determination of the matters arising from the Muslim marriage, hadana, maintenance and all that. He will receive that document. He will have to now work to find a resolution. So you're starting off a process, mediation. If that doesn't work, there's a potential for at some stage in the process, 95% of your disputes will be resolved without going to court. All right. And at minimal costs, because legal aid will also be available. So you can invoke legal aid if you can't afford a lawyer of your choice. Then, coming back to other practical problems, let me give you another example now. This relates to, and this is quite common also in the community, fasq, where the husband refuses to issue a talaq, right? You find that quite often, I can give you several examples. Parties were married, Zayd and Amina were married and concluded a valid nikah, right? After 2 or 3 years, the marriage, Amina wants out because of a fundamental incompatibility, right? Now, what happens is the husband says, I'm not giving you a talaq. You either come back or that's it. I'm not, under no circumstances, you either reconcile and come back to my home, or I'm not giving you a talaq. Right? It's quite, right. So what do you do now? The wife's right of recourse, because there's no tafwidut talaq. If we had a marriage contract and she had the tafwidut talaq, right, conditionally or without conditions, that was a way out. And the wife could have then exercised it, or somebody on behalf of the wife, depending on the terms of that tafweed, could have exercised the talaq. So she's now sitting there, she can't get remarried, she needs an out from this marriage in terms of Islamic law. So then, her only option is to get a fasq. Fasq means a dissolution of a marriage. Now, in South Africa, we don't have, at the moment, we don't have a Muslim marriageable, nor do we have any organized system of qada here, even on an informal basis, nationally, right? So she'll go to one of the judicial bodies or a scholar to look at and make an application for a fasq. Okay? Now, currently, we apply here in South Africa, you see, because we don't have a qadi, in terms of the Maliki fiqh, there is a provision that if you don't have a qadi in a particular area, or if that qadi is not reliable for whatever reason, then you can form, if you have if three individuals sit together, they will perform an adjudicative function. They will actually be deemed to be judges for the purposes of hearing that case. All right? They'll take the place of a qadi. So that's what we call, you can have a judicial committee. Now, I'm not talking about in terms of a recognized system, but on an informal basis, that can sit and listen to the case. But then women complain, they say, we go to ex-judicial body, we are sent from pillar to post, there's no proper organization, there isn't the committee, we gave our complaint, the husband came and said something else, that when months have passed, in the one case, 2 years passed, 2.5 years passed, I haven't received my talaq, or at least a dissolution. What do we do? Right. So we're getting, these problems are ongoing. Then you could get one judicial committee saying, all right, there are grounds for a fasq. Husband may say, look, I'm not attending, I'm not interested in your committee. She must come home and stay with me and reconcile. I'm not giving her the talaq if she wants. That's the end of the matter. I've consulted my imam or my alim or whoever I've got confidence in me. He told me I'm on the right road. End of matter. So now that committee, let's assume, gave a talaq in his absence. Then he could go to another committee somewhere else, and that committee can say, no, the talaq wasn't valid. Goes to another Darul Ifta, that Darul Ifta writes a fatwa and says, no, it's not valid, because in terms of the Hanafi law, Hanafi fiqh, for example, al-qada al-ghaib is not valid. You can't give a judgment against a litigant who's not present in his absence, as opposed to the other schools. Shafi school, yes, it's valid. You see the problems that arise because you could get potentially conflicting decisions, right? Or the one judicial committee issued the fasq, which has the effect of a talaq bain, then she's getting married tomorrow. This ex-husband could phone the girl's party and say, no, she's still married to me, I never gave her a talaq. All kinds of problems can arise practically. So this subject is a very sensitive subject. It creates acrimony, it creates problems and so forth, and you need a statutory system, a viable statutory system to regulate issues arising from Muslim marriage on an enforceable basis, right? So then, now also the grounds of fasq are an issue. In the Hanafi fiqh, there are very narrow grounds of fasq, right? For example, in the Hanafi fiqh, if you fail to maintain your wife, that's a ground of fasq, right? That's obvious. If the husband is impotent, that's a ground of fasq, for example. But if the husband disappears, right, then if he was 40 years old and he disappeared, just suddenly disappeared and went off somewhere, we can't trace him, he's in Australia, America or somewhere, left his wife hanging here, and he's 40 years old and he's living in Durban, and the average life expectancy in Durban is 60, for example, for males, then she's got to wait for 20 years. Right, in the Maliki fiqh it's 4 years, in the Hanbali fiqh the Qadi has a discretion to terminate the marriage. But in the Maliki fiqh, the grounds of fasq are very broad, the most broadest compared to all the schools. And that's why in India, this ulama of India adopted the Maliki fiqh, because the Hanafi fiqh was not workable. Women were suffering on the ground, and there was a danger. A woman can say, like they can say in commercial matters too, you know what, Islam doesn't have a solution for me. Right? And na'uzubillah, that could lead to some kind form of irtidad or whatever else. So we have to draw from all the schools to find that solution that is most compatible to a practical situation. Right? So then, like in Islamic finance today would never have worked unless we drew from all the schools, right? So here, Hanafi fiqh is narrow. In the Maliki fiqh, you got a number of grounds of fasq. One of the grounds of fasq is shikak, irretrievable breakdown of the marriage. Another ground of fasq is darar, harm, recognized harm. In fact, some of the fiqh material in the text in the Maliki school make it very light also in some cases. If the husband calls the wife's father a dog and that kind of thing, that could also be a ground for constitute a darar. So the Maliki fiqh is, in fact, for the Muslim marriage bill, we drew heavily from the Maliki fiqh. Then in the Maliki fiqh, they have the Sudanese code and of Ahwal al-Shakhsiyya, Muslim family law, and maybe some other codes also have incorporated. The Syrian code, I think, also have incorporated the whole question of arbitration. The verse I mentioned in the Quran, what happens is when there's a matrimonial dispute, the Qadi will appoint 2 arbitrators who will fully investigate the matter, right? They will try to reconcile the parties. And if that fails, then they will submit a report to the judge. And in that, the judge will study the report, and if they recommend that the marriage should be dissolved, then the judge will issue 1 talaq-e-bain. There are different variations as to what the judge can do and can't do, and it's based on certain rules. But so there it is. So the solutions are all there. I always say the Sharia has solutions to every problem. It's only a question of education, a question of knowledge, a question of learning as much as we can, and working on a collective basis, benefiting from scholars, and also doing our own reading and making our own inputs, and thereafter finding practical solutions solely for the pleasure of Allah, not to be divisive, not for any egotistical purposes, but really to work collectively to find collective solutions for the benefit of the Ummah. So, with these few words, I didn't prepare anything special. I just came and spoke. I thought I'll mention some points to you to instigate an interactive discussion, because these matters are primarily practical, and the problems really start on the ground. Muslim family law per se is obviously an extensive subject. There's a whole host of jurisprudence that relates to Islamic family law, and of course Islamic law of inheritance, which is also part of the whole Ahwal al-Shakhsiyya, and that deals with nikah and meher and talaq and the kinds of talaq and nasab and what are grounds of fasq and khula and all these things, the whole system. There's a recognized system, and also it doesn't only stop there. I mean, the family law also covers maintenance, not only between husband and wife, between parent and child, right? So if we have an enforceable system here, if a mother or a father is elderly, the child doesn't want to maintain the parent, at least the parent has the right of recourse. They can institute an action within the framework of a Muslim marriage bill, right? Not in terms of Roman Dutch law or anything else, but Muslim marriage bill, Sharia compliant manner, right, and move forward. The problem is, whilst I concede, right, that the bill may not be ideal, you're never going to get anything that's going to satisfy everybody. We are living within South Africa, it's a secular society, right? So, but you have to weigh the bill on the one hand, on the one side of the scale, and the existing status quo, what we have at the moment, on the other side of the scale. I mean, just a month ago, one elderly mother went to the domestic violence court and got an interim order against her son. Her son was adult, he's married, he's affluent, because the son, she alleged that the son was abusing her, right? They were living in the one building in the different parts of the building. So then I'm just giving you that example to show you that currently men and women, Muslim men and women, are going to the secular courts and using the secular legislation, right, to try and get some justice. They got no option, right? So if you put that on, that's not permissible from Sharia perspective on a technical basis. So on the one hand, if you put that situation on the one side of the scale, where you are adopting an un-Islamic option, all right, the wasail is not Islamic, the method is not Islamic, but you got no option. People become desperate, so they use the courts. Courts are giving rulings which are contrary to Sharia, so you're still getting jurisprudence being developed which is inconsistent with the Sharia. You put that on the one side of the scale, and on the other side of the scale, you put a viable statutory framework, a bill which the community can use to try and achieve Sharia compliant solutions. Now, you put them together and you weigh them, which is better, right? What is akhafu dararain, which is the lesser of the two evils? This, getting a viable statutory framework is more beneficial to the Muslim community. It doesn't guarantee, maybe there may be some cases which may not be determined or whatever, you may get the odd judgment which may not be Sharia compliant, but you'll get few judgments if you educate the community and you get the bulk of your disputes resolved internally within the framework of the bill, because now you've got an enforceable system. We have to get our systems in place. That's the important thing. We need to get prepared for this. But if the community is going to be divisive and they're going to start arguing and fighting, and this is not Sharia compliant, and this is haram, and this is kufr, and this is fisk, and all that, and all these fights, then here the government will sit back and say, we want to give you all something, because the Constitution recognizes this in section 15. It says that the state has the power to pass legislation recognizing the personal law of a community. It's not like the American Constitution, which is neutral when it comes to religion. Here, this is embedded in the Constitution. So, if we're going to carry on bickering with each other, then we're not going to get what we're going to achieve, and just carry on moving forward with a sense of disunity and not in an organized and diverse. This is ultimately for the community. No individual is going to profit from this. So Muslim family law, obviously, to summarize, there are two elements to it. The one is, informally we have to educate ourselves. We have to, whether we get a Muslim marriage bill or not, we have to get solutions. Within the framework, we must get our marriage contracts in place. We must educate our community. We must have informal mediation systems, arbitration systems informally, to try and resolve or try and have the bulk of our disputes resolved within a Sharia compliant framework, whether we get the Muslim marriage bill or not. And of course, the other part of the coin is to get a Muslim marriage bill. And there's also another extreme, and that's due to lack of education. Recently, I had a matter where the parties were in an Islamic marriage, and the one party had a very distinguished position, the husband. And for whatever reason, after 30 or 40 years, the marriage broke down, they had elderly children and so forth. So now we were entering into a settlement. And the husband was quite generous, you know, a tabarru. This is the other part, the compassionate part of Islam needs to come out also. Islam is not only sticking to legal rules. There's a compassionate element. The Sharia is made up, like Imam Razi says in his Tafsir Kabir, Al-azmatu lillah, the one part of Islam is to have the azma of Allah subhanahu wa ta'ala, and the other one, and all the ibadat, and the other one is a shafqatu lil khalq, compassion for other human beings. So here was the man who said, okay, after 20 or 25 years of marriage, it's not working out now. The reasons are not relevant. We are in an Islamic marriage. The children are all adult. I'm only obliged to maintain you for the period of iddah. I'll give you an apartment, which I'll transfer in your name. I'll give you a substantial amount of monthly maintenance, right, for the period of your life until you remarry, right, and get another source of support. Okay, plus I'll give you certain cash payments over a period. Now, this is tabarru, generosity. You know, Allah will reward him for that. And of course, she wanted more, because then when she came with the representatives, she wanted much more. Right? We finally settled. And when I told her that, listen, you know, from Sharia perspective, this is all you're entitled to, she says, well, leave Sharia out of the picture. It's not relevant at the moment. Don't talk about it. We're dealing with, right? So, why? Because she could have gone to lawyers and issued a summons and claimed a universal partnership and harassed the man, tried to bring him into disrepute because he's of a high position. I don't want to mention in what area. So his name is going to come in the paper and all that. So, you know, so there it is. So, finally it got settled. But the tabarru is also, we must also inculcate amongst the Muslim community compassion, which is the source of Islam. You know, فَإِمْسَاكٌ بِالْمَعْرُوفِ أَوْ تَصْرِيحٌ بِالْإِحْسَانِ. You know, ihsan. Retain them in equity or release them with ihsan, with that compassion and love. So this compassion is very central. And in the Hanbali fiqh, in the Maliki fiqh, if you make an undertaking in a marriage contract or in a settlement, for example, which you are not obliged to, but you make an undertaking, then that's binding. They call that al-iltizam bit-tabarru, an obligation to enforce. So for example, I say, I undertake, or Mr. Zaid says, Mr. Zaid undertakes to pay, say Mr. Zaid met an elderly lady and he found her destitute and he felt sorry for her. Right? And he's got the means. So he gives her an undertaking. He says, okay, I undertake to pay you 2,000 rands every month for the next 5 years. Right? Now, he wasn't obliged to make that undertaking in strict Sharia law, because there's no relationship between them. If he went to a Qadi, the Qadi is, of course, compassion and is different thing. He gets reward for it. You know, there's no Baytul Maliya or state treasury or something, she's needy. But if he makes that undertaking, then in the Maliki fiqh, it's called al-iltizam bit-tabarru. That undertaking is converted to a legal obligation. You go to a Maliki Qadi, he'll enforce it. And in fact, in today's South African law, you can enforce it if it's a proper undertaking. And even in certain other jurisdictions. Wa akhiru da'wana alhamdulillah.
Some question?
Yeah, no problem.
Jazakumullahu khairan. Important topic, ya Mashaykh. And especially almost every single one of us, we probably have somebody in our family who's been through matters like this, from pillar to post. Maybe the sister wants out and years have passed and she's just hanging. If, for example, even without MPL, if they had a proper marriage contract, that if we have issues, problems, then this group or that number of people, they can sit and decide the matter. Delegation or tafweed of talaq had been given to them. I mean, then the matter could have been resolved very, very easily, and other problems also. If there's any questions, you know, the floor is open, inshallah. You can ask your questions, inshallah. Fadl, Ali. Yeah.
Alaykum salam.
I had a person recently came to speak to me. The husband married this woman, they haven't had any relations or no physical relations. Over a year they've been married.
All right.
She wants to get out of the relationship because nothing happened over a 1 year period.
All right.
Has she got any way out? Because he won't give her.
He won't give out the luck. Yeah. So,
He wants her to pay her $1 million.
sure. He wants to do a khula. Yeah.
That's riba.
That's extortion. So what was the cause of him not consummating the marriage? Yeah.
There are many stories.
Is it?
Relevant.
Well, you know what? You need to establish a committee of 3 persons. What you need to do, say for example, here, Al-Kawthar Institute, I'll give you what should be done, right? You'll establish a committee of 3 persons. They will be it will be a judicial committee, okay? So in the Maliki fiqh it's valid, but the 3 persons must arrive at the decision by consensus. Then you must issue a letter. Now, it has to be a very impartial and transparent process, right? Issue a letter, a document to the husband. Firstly, the wife must come in, you must take a statement from her, right, as to what her complaint. She must lodge a complaint as to what the full reasons for all her complaints and what she wants and what remedy she's seeking. Then you'll send a letter to the husband and tell him that your judicial committee has been approached and you're having a hearing on a certain day, and of course he's free to send his submissions in response, and then the committee on that day can be divided into 2 parts, the function of the committee. The first part would be an attempt to mediate the dispute. If you can mediate the dispute on a reasonable basis, end of matter, right? Then that becomes a sulah, and there's no need for the committee to hear the dispute. On the other hand, if the committee, what you call, if the committee, then say if he doesn't, the committee can hear the case. Then you've got to follow the Islamic law of evidence, which means that al-bayyinatu lil-muddai wal-yaminu ala man ankara. So the evidence, the woman who will give evidence first. All right. It depends on what he disputes or doesn't dispute, because she may need witnesses, but sometimes she doesn't have witnesses, She needs 2 witnesses. But anyway, sometimes circumstantial evidence is sufficient in the discretion of the committee. So the committee will hear her evidence, if any witnesses she has. There may be some cross-examination. He can ask questions. Then she closes the case. Then he gives his evidence. All right? And you hear the evidence, and thereafter the committee will deliberate, not immediately, will sit, reserve and deliberate the matter, and then see if on the basis of fiqh whether there's a basis to dissolve the marriage, across the board. There are a number of grounds of dissolution. For example, in Maliki fiqh, like I said, shikak itself, irretrievable breakdown, then lack of compatibility, is also there's evidence in Maliki fiqh to establish that there's lack of compatibility. So you've got to start this process. And there's one more leg to it. If he doesn't appear, then in the notice you must tell him that if you don't appear, you're risking it at your peril, because then the committee will listen to the evidence of only the female, and he runs the risk of an adverse ruling against him. So it's not difficult. It's a fair, impartial process that can be done. Just that you just need to have your procedures in place, and that can be initiated, and you'll find that. But you must move quickly and speedily. Right? And that what we call in India, they call it panchayat. In the old days, that committee used to be. But here, what now? This committee, you must get your. Al-Kawthar must select the committee. It must have scholars, solid people on the committee. Preferably, they should be alims, but you don't need an alim on the. You can even broaden it. Minimum 3, you can have 5. on the committee, right? But the Sharia issues will be resolved by the scholars on the committee, right? So that's that. You start off a process, and even you can say that because if you don't do that, and if you don't say it, he's not going to do anything. You're going to get no. I remember in one case there was a matter where I was. This is confidentially because within this circle, I was forced to intervene at some stage. This boy and girl were married. They were in the community, and then the boy he didn't want to break the marriage, but the girl wanted an out. Now, the reasons are not relevant, right, at this stage. So there was her view. In simple terms, she said there's a fundamental incompatibility here. But of course, he wanted the marriage and all that and so forth. So he refused to give her talaq, hoping, and so she was running from pillar to post, like Sheikh said now. Jamiat, there, nothing happening, 2.5 years. And sometimes people are well connected, they speak to somebody, he speaks to somebody, so, thing just carries on rolling over. So finally, what we did is, the same advice I'm giving you now, I set up the committee, we followed the due process. It must be due process, Sharia compliant due process, like a legal due process. The Prophet said, don't give a judgment hatta tasma kalamun akhar, until you hear the other side. Right, now this principle, what they call in modern law, audi alteram partem, hear the other side before you make a decision. It's part of labor law now. It's a core concept in administrative law, not only in South Africa, England. It was established by the Holy Prophet ﷺ when? Long ago. So you can't make a decision. You've got to hear both sides of any version. So you must be fair, transparent, due process. Right. We initiated this. And then even before the hearing, he sent the talaq by fax. He had his own scholars he was commenting, and he realized now that the game was up. Right. He saw the thing because eventually so the same story here. You need to have a process, and you must be fearless in these matters. You must do what you believe is right. You must be fearless. There's lots of juridical authority in Maliki fiqh and others, and there's scholars who can assist. There's material that's available. There are books that have been written. There's family law systems in Egypt running since 1929. In India, you've got, the secular courts, the Dissolution of Muslim Marriages Act, they adopted the Maliki Code, which was agreed to by the ulama of India. Right. So there's materials available, and it's a matter of having the processes in place. But you must do it carefully, competently, and properly. Anything you do as Muslims, you must do it to the best of our ability. The highest levels you must reach, In Allah katab al-ihsan. You mustn't be cowboy style. Then you're going to have more problems. So it's not difficult.
Question here, maybe a common question. A female says that they were married for about 20-30 years, and they had a nikah, and soon after they registered the marriage community of property. 30 years later, marriage is dissolved. He claims that I just signed it because I was told by family to sign this. I didn't know exactly what were the repercussions of signing community of property. She asks, and she's religiously inclined, etc. She asks, does she have the right to take him and hold him, to that document and claim half of his property?
Yeah. You see, community of property, you're not signing a document with community of property. That's the difference. There's maybe what she means by signing is, you see, in the South African legal system, right, we have a civil legal system. And within the civil law, we have the Marriage Act, then we have the common law. Now, what community of property means is if both spouses go before a marriage officer under the Marriage Act and they contract a civil marriage, right, automatically by operation of law, that marriage is deemed to be a marriage in community of property. The only way to avoid that consequence is to enter into an anti-nuptial contract, and then you register your marriage. Or you don't register under the Marriage Act and just enter into an Islamic contract, and that's the end of the matter. Nikah is sufficient, but nikah preceded by an Islamic contract is sufficient, right? And it's recognized in terms of the law. So in her case now, you see, it's not like he entered into a partnership. Say if he entered into a partnership, for example, say if he was married, she was married to him in community of property for many years, and they converted that community into a Sharia compliant partnership. How? They met and they said, okay, you know what, legally you got half, I've got half. In everything there's a joint ownership, half. It's just one joint estate which is merged together, right? And that estate is only divided upon termination of the marriage by death or divorce. Then it gets split into two halves, right? So whether the wife contributed 100 rand, the husband contributed 1 million rand, or the husband contributed 100 and the wife contributed 1 million, it's all 1,100,000, half. So now, so that happened automatically, right? Now, from Sharia perspective, unfortunately, she's in a precarious position because there is no Sharia justification that I can see, right, in terms of which she can claim half his estate, right? Because they didn't enter into a recognized Sharia contract, partnership contract, or some arrangement where they, or there was an ikrar from his part, or something which we can say from Sharia perspective, there's sufficient Sharia evidence to establish her entitlement to that half. So she's in a what now, very sensitive situation, right? Like I said earlier on, if the husband made a tabarru and said, I'm happy to give you half or a proportion of my estate, that's fine. But as matters stand, you know, I understand her dilemma, exactly where she's coming from. And, you know, women today get destitute, you know. The reality is security is a major issue for them within the South Africa, in a secular society, right? I mean, I had one elderly lady once, I just assisted her. Unfortunately, my rates are too high, so we do try to assist wherever we can. But, you know, so she phoned me and said, you know what, please, can I see you this, that, and the other? I said, no problem. You know, we all want sawab, you know, we need somebody's pious du'as. That's really, that's going to make it or break it for us when we leave. So, anyway, this lady came, and I was so sad to hear, you know, she broke down there. And she was from another area, another province of South Africa, and she was there. She was married initially, and she had a child. I think her husband passed away or something, and this man came to her from Durban, another area of Durban, I don't want to mention, but, and said, you know what, don't worry, you marry me, I'm very affluent, I'll do this, and I'll buy you a car, and I'll do this, and made all the promises of the good life for this poor lady. So there she went, fairly young lady, married him. But tragedy, he never fulfilled any of those promises. Right? Now people have, you know, now this is the Muslim community, you know, you see people, then he stripped his assets and passed it to his children now, you know, to his son. So he's got nothing in his name. She's got no claims against him. Right. So this is the kind of, you know, sometimes people we get, despite, I mean, sidq is the central core element of our deen, but no transparency, no honesty, is dishonesty and so forth. So poor lady wants to know what are her rights. Right. Now coming back to the Muslim marriage bill, okay, if there was a Muslim marriage bill, we could have, because we have inserted a provision, you know, on the tangible contributions that is included there. I personally wrote that because I was responsible for drafting the bill, and I put in the provision, but I consulted my teacher, Sheikh Taqi Usmani, who was world authority in Sharia. So he said, look, put it in, right? And likewise, we consulted other scholars also. I mean, the Chief Qadi of India, my first teacher, plus we had the Sharia Institute of Pakistan and other people who came, late Dr. Mahmoud Ghazi, you know, it's a wide consultation. We were getting inputs from everybody. So, what now? That provision is there. Now, for her, what do you tell her? I told her you can go to the maintenance court, right? Your maintenance court is there. You go to the maintenance. There's no legal cost involved. They will institute the inquiry. They will convene the maintenance. He'll come to the maintenance court. He says, I'm unemployed. No salary. Nothing. I got nothing. Right? Because he's stripped. He's got nothing in his name. He's got one son from his first wife. So you see, coming back to the point of I can understand this lady's concern, because here's a woman who gave her life, her future, everything, spent 15, 20 years. Now this man is treating him terribly, mainly using her as a cook to cook nice food for him, and basically breached all his promises. She's got no security. And in our society now, from a Sharia perspective, she went home, right? The obligation to maintain her fell on her parents. Obviously, she's probably her parents are deceased, right? Then falls on her brothers. Now the brothers, I'm not talking about her, but generally each one have their own responsibilities. Some are affluent, they're too frugal, they can't part. Others, they got their own families and responsibilities, they've got limited income, you can't expect them to really assist in any material. So what do you do? The Prophet said, Ana waliyun man la waliya lahu. I am the guardian of those who have no guardians. But there's an issue that, it's the issue of security, you see, here. So, this is where your marriage contracts and your partnerships should come in, where right up front, if you're married in community, make it into a Sharia compliant partnership. So legally it will be a community and Islamically it will be a community, half-half. Then if there's a dissolution, she'll get half, she'll on a halal basis. If the husband dies, she gets half, that's her Sharia share, plus she gets 12.5% of his half, she'll end up with at least 53, 54%, of the estate.
Any more questions, Mashaykh? Any questions? More questions?
Ji.
Just check the comment, just a few minutes, on the Muslim marriages bill.
Ji.
Because I think it's quite of interest to the ladies. Just a pertinent point on that.
Muslim marriages bill, just to tell you in a summary, what happened was in March 1999, the then Minister of Justice, Dr. Dalla Omar, who's passed away now, may Allah grant him the highest ranks in Jannah, he initiated a project under the auspices of the South African Law Reform Commission. Law Reform Commission is a statutory body, whose function is to assist government in law reform in the country. So if they have a project, whether it's marriages or arbitration or anything, Children's Act, they investigate it thoroughly, they consult, they publish a report, they have their own internal processes and ultimately issue paper, discussion paper, and then they make a recommendation to the Ministry of Justice. Ministry of Justice will examine the report, there's a draft bill, they may make changes to it, they may implement it or may not implement it. It becomes law, or they may change existing law. So the terms of reference of this committee was to inquire into Muslim marriages and make appropriate recommendations to the minister. Committee then was chaired by Judge Muhammad Nafsa, who's a very able judge. He currently sits on the Supreme Court of Appeal, SCA. He's the only Muslim, SCA. He's quite the Islamically conscious Muslim judge. So he chaired the committee. There were other members of the committee. I was also a member of the committee. And so this committee then, these members were appointed by the minister, but there were some workshops held before that and nominations were called and so forth. Okay, there were women also on the committee. Committee then finally prepared a draft bill, and the draft bill was approved by the executive of the South African Law Reform Commission and submitted to the Ministry of Justice for consideration. The bill sat with the ministry for a number of years, 5-6 years, because of conflicts in the community. I think every minister that came felt nervous to deal with it, or they had their own commitments. They said this is now causing the community's got lots of issues with this and that and so forth. Then recently, about 2 years ago, the Minister of Justice then took the report of the commission. We, the United Ulama Council, which is the national ulama body, made some supplementary submissions, and then they looked at the bill. They removed certain elements of the bill. In the original bill, we had provision for mediation, voluntary arbitration, a Muslim judge assisted by 2 Sharia scholars, dispute resolution mechanisms, right? If there's a dispute, firstly, if a talaq is given, it has to be registered, right? Husband must be present, talaq takes effect, then the process starts, a summons is issued, and the legal process starts. Wife can get interim maintenance for herself and children, and until the process is completed on a pending basis. And then you had the parties' compulsory mediation. They had to go to an accredited body to try and mediate the dispute. If that didn't work, then they could go to court, or they could opt for arbitration with an accredited body, right? And then there was an appeal process. Of course, maintenance and other issues, custody and all, was dealt with in the bill. So the ministry looked at the bill. They removed the reference to the Muslim judge. They removed voluntary arbitration, made certain other changes. They issued it for public comment. There was a lot of debate, and people said, oh, it's not Sharia compliant and kufr and all that. So all the inputs were sent back by different bodies, for and against. Some people sent one-liners to say we're against the bill, on a joint basis. Then the ministry collected all the inputs, right? They identified the issues, and those issues, they identified 4 key issues. And they had a meeting with the United Ulama Council. I was present, and then I made some submissions to the ministerial task team in relation to the 4 issues on behalf of the United Ulama Council. Right. Now, those submissions are back with them, and the person in charge of the task team was working with the report, and he had to submit the final recommendations to the minister. Right. Now, it appears to me that all the recommendations we made, he's going to reintroduce arbitration and the other clauses we want introduced. The problem is it goes to the minister's level, then he's probably going to meet the United Ulama Council again, and then the bill has to be certified to be constitutionally compliant. It's got to be released to the portfolio committee. There'll be a further round of Justice Portfolio Committee, further round of representations, and they could be, the bill could be fine-tuned or not, and ultimately it goes to Parliament. But now, as we stand, we still stuck in the process. There's no guarantees as how things will pan out as we move forward.
حياكم الله جزاكم الله خيرا بإذن الله تعالى. We'll meet up next week inshallah and continue. We want to thank brother Shuaib Omar for joining us and spending his time with us and elaborating. جزاكم الله خيرا. السلام عليكم ورحمة الله وبركاته.